Minutes time, and we talk sometimes about the importance of prenuptial agreements. Well, the flip side of cohabitation agreements is children pushing their aging parents to protect family assets. When the 2016 census was released, one of the revelations was the rapid increase in the number of people 65 years of age and older. Divorce among this segment of the population is also rising. But what are the risks associated with seniors choosing to live with a new partner? Joining us to talk about this, Laura Paris, associate at Shulman Law Firm. Hi, Laura. Thanks for doing this.
Hi, Barb. Thank you so much for having me.
So this is interesting. It's not one we think about often, but there's actually a term for people who are older when they get divorced.
Yeah. So typically we refer to this as gray divorces. Basically what happens is when you divorce later in your life and you want to enter into a new relationship, you shy away from actually going back through a marriage, which could potentially lead in divorce, and you are more inclined to enter into a common law relationship.
Okay, so I'm sure you have a number of adult children looking at their parents, first of all, probably being a little bit concerned that their elderly parent is being taken advantage of by somebody, and worried about the family assets as this parent enters into a new relationship.
Absolutely. So those are two of the main issues that you find children are concerned about. One is these what we call predatory relationships, and this is a developing phenomenon where spouses basically take advantage of elderly people and assume control of their finances. And you find that at Shulman Law Firm, we find that we have children coming in very concerned about what's going to happen to their assets in the event that their parent separates or passes while being in this relationship.
Yeah, so let's look at a couple of things, because one, I want to talk about how long the parent has to be with another person to be considered common law. But the other thing I wanted to ask about, and I'm sure this would be a concern for a lot of adult children, is not just that aspect of it, but is somebody going to get my mom or my dad to change their will?
Absolutely. So, first of all, to answer your first question, in order to be considered a common law spouse, you need to be cohabitating for a period of 3 years, or if you happen to have a child with the person, then you have to be in a relationship of some permanence to be considered common law. To answer the second part of your question, when you are I'm sorry. So
it had to do with the will situation.
Correct. So people think that just because a will may be drafted in a certain way that leaves certain assets to children only, that they're protected, but that's not necessarily the case. When you're in a common law relationship, what may happen if you pass while in a common law relationship is that your spouse could potentially have a claim against your estate for spousal support. The other issue, as you mentioned, is that sometimes in these predatory relationships, what happens is these predators, for lack of a better term, take advantage of their spouse and have them actually change their will in order to ensure that they're receiving something upon their passing.
I don't think we want to panic everybody who's an adult child whose parent is in a new relationship. I mean, is this a really common thing, this whole predator situation, or would you say there are equally or maybe more relationships that are just good, healthy kind of companionship sort of relationships?
It's hard to say for certain. I do like to believe in the good in people, and I like to say that it's more often that you find that these relationships are just normal relationships, and they're not being entered into for some sort of financial advantage. But you definitely need to, stay on alert, because this does happen. And unfortunately, I think it happens more than people like to admit.
Really? Are you seeing that in your practice?
Well, what we do see at Shulman Law is we have the children coming in, and they're actually coming in for advice to try and figure out what they can do from their end in order to basically protect their inheritance. And when these circumstances happen, I mean, there's not much that a child can do, being that it's not their asset and they're not actually a part of the relationship. But what we can do is we can give these particular clients advice in terms of how to inform their parents, who may not be aware of what the current laws are, on the possible implications of being in these common law relationships and how it may affect their assets and ultimately their estates if they pass.
Laura Paris is my guest. Laura, are there some red flags that children should watch out for in terms of their older parents being in a new relationship? Are there some red flags that show there might be a predator involved?
I think one of the main things that you would look at is possibly an age difference. Sometimes that could be one big thing of alarm. The other thing would be if you start to notice a sense of control when you're with, if you notice a change in the character of your parents. So, for example, if you're with them when they're not with the person, and they're one way, and when they are with the person, they're a different way. So if you start to see a change in the dynamics of the way that your parent typically is, that could also be a cause of concern.
And I can, sorry, go ahead.
One other thing is that if typically with aging parents, you find that children are the ones that are controlling their finances. They're helping them pay their bills, do their taxes, etc. If all of a sudden that role is passed on to a new spouse, that could also be a cause for concern.
Well, and that's exactly where I was going. I kind of had a different thought about it, but I was thinking, you're not just talking about family assets being protected in terms of they have money in this or money in that. If your elderly parent has access to a pool of money and trusts this new person and gives them access to that money, the fear is that money will be drained by the other person. Absolutely.
That's a very definite fear. And this is what I'm saying, where it's important that children, if their parents aren't taking the steps to be informed, that children take these steps and they inform their parents, and they make sure at the end of the day that not only their potential inheritance is protected, but their parents' assets are protected, because you never know what may happen when people get older. Illnesses may come about. There may be money that's required for old age homes, etc., and that could be quite costly. So if a parent has a fund that is potentially an emergency fund, and you have a spouse that is depleting this, that could be very harmful in the long run if they end up needing that money for medical treatments or to stay in a home or whatever it may be.
Is there ever a scenario where a parent will pass away? Is there ever a scenario where the kids end up having to pay spousal support to the partner?
It wouldn't be the children paying. It would actually be paid directly from the estate.
But so that money would be allotted from the estate to pay spousal support.
Correct.
And that's money that would not go to the children.
Correct. So I mean, it could have been that the property was intended to go, or the assets were intended to go to the children, and then a portion of it is not coming to them because their parent is on the line for a potential spousal support claim. Very interesting stuff. Thank you so much for joining us. Thank you for having me. Laura Paris is an associate at Shulman Law Firm. Coming up in the news, we have an up in the news. 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 We have an up in